Continue on. Just to remind people to turn their mobile devices off as it interferes with their recording equipment. There's Sammy that give us recording issues. Can welcome Bronwyn to the committee. I know you have to leave fairly soon, but you're very welcome to the committee, and thank Chris for his contribution as a member over the last year or so. And just to inform the committee that a copy of the entries into the register of members' interest for Bronwyn has been circulated at page 3 of your tabled papers. Agenda item 1 is apologies. We've received apologies from Stuart Dixon and Patsy McGlone. Are there any other apologies? Nope. Okay. Agenda item 2 then is draft minutes of the meeting from the 10th of September. Can I just draw your attention then to those at page 5 through to 12 of the folder. And if you just want to quickly glance over the minutes and indicate if you're happy enough for me to sign them. Everyone happy enough? Yeah. Okay. There we go. Matters arising then, we have correspondence from the Causeway Coast and Glens Council just on the proposals to rationalise the Courts Estate, and a copy of that correspondence is at page 14 of your meeting folders. Just really to note that at this stage, just to remind members, the Courts and Tribunal Service are due to attend in November with the results of the consultation on that rationalisation of the Courts Estate. I suggest we could guess what the results of the consultation will be, but we can return to it at that point. Agenda item 4 is a review of the law on unduly lenient sentences. Department officials will attend to outline the results of the consultation and proposed way forward in relation to the review of the law on unduly lenient sentences. The relevant papers members can find at page 20 through to 90 of your meeting folder. So can I welcome Karen Pearson, Deputy Director of Access to Justice Directorate, and Tom Hare, who is the Head of Criminal Law Branch. And just to remind you that the meeting is being hand-sorted, but whenever you're ready, if you want to make opening comments on the results of the consultation, then we'll open up to questions afterwards. So,
thank you very much. Thank you, Chair, for the opportunity to update the committee with the results of the consultation exercise on the law on unduly lenient sentencing, and we'd like to outline the Justice Minister's proposals for the way forward. Hopefully members of the committee have a copy of the report and will provide a brief overview. If I can just maybe summarise the presentation in a couple of sentences first. We're proposing some short-term actions to respond to some of the specific issues arising from the review, and then to follow that up with more detailed consideration of the consultation exercise. So we have some interim proposals to recommend today, Chair. As the report indicates, the consultation ran for 13 weeks from February to May, and we attracted 13 responses, and we were very pleased to receive those. The department had identified 4 main areas for the review to look at. Those were to ensure that we had a process that firstly focused on the most relevant cases, secondly enhanced confidence in the justice system, thirdly maintained court and prosecutorial independence, and fourthly provided a deliverable and manageable procedure. And we sought views on a range of topics, both on process and content of the current scheme. On process, we asked, was there a need for such a scheme to remain in place? What form should it take and what timeframe should it run over? And on content, we sought views on the scope of the scheme. For instance, had we caught the right offences so far to date? And on the outcome, we received a range of responses, 13 in total, that covered broadly 6 themes, some very general, some very specific. On the general points, there was support across the piece for continuation of an unduly lenient sentencing scheme, and there was support for the current existing core principles of errors of judgment and undue leniency. And by and large, those 2 points have already been established in and confirmed by case law, but it was reassuring to have the support for those principles from those who commented in consultation. It was recognised that those were very important principles and that the ULS scheme should not be a broad further right of appeal for those who just do not like the sentence handed down by the court without any underlying analysis of that. In terms of process, there was support for the safeguards that are within the scheme already. These are the continuing role for the DPP to consider and refer applications, and to require the leave of the Court of Appeal, and finally to have a 28-day time limit. That's very important to us, we think, for victims to have clarity on the sentence handed down. And we don't propose to make any changes to those three areas. And specifically, we received points in relation to specific offences and categories of offences and the scope of the scheme. outline those very briefly. On the offences, most of the respondents commented, and not surprisingly so, it's really what we wanted to hear back. And the responses varied between those who wanted to add to the existing list and those who wanted to just make the scheme more broad, or indeed add categories of offences. So the Minister wishes to bring forward an order as a result of the consultation to add some further offences to the list, and I'll just read those into the record if I may, Chair. Firstly, possession of indecent photographs of children, and that's in relation to Article 3, Protection of Children, Northern Ireland Order 1978, and Article 15, Criminal Justice Evidence, etc., Northern Ireland Order 1988. Inflicting bodily injury with or without a weapon, Section 20 of the Offences Against the Person Act 1861. Offences of an authorised or harmful deposit or disposal of waste, Article 4 of the Waste and Contaminated Land Northern Ireland Order 1997, and offences of slavery, servitude and forced or compulsory labour, Section 71 of the Coroners and Justice Act 2006. We also had a number of people ask us to add animal welfare offences to the list, and the Minister's very much minded to do that, but he wants to await the result of the joint review he has with DARD, which should finish towards the end of this calendar year, and he will then be able to bring forward an order covering all of those provisions and the specific animal welfare offences arising from that review. On the scope, we also looked at the schemes in terms of the court structures that are engaged. Our view is that these should remain as they are at present. We did look at whether we should go for a simpler approach whereby any case in the Crown Court could come within the scope of the scheme. We did some analysis of this, and we think that could add another 800 offence types to the list, and we think that just needs a lot more analysis before we would make a recommendation of that sort. The impact on the court could be considerable, and we don't think we should rush into that at present. And the Minister noted that some of the responses did comment on the impact that could have on the DPP and on the court. We recognise that that isn't the end of that particular issue, and we wish to give further consideration to that. We also think it's really important that everyone has clarity on the scheme, what it's there to do and how it can apply to them. That's particularly true for victims. We'd also like to do some work on a guidance note so that victims can be absolutely aware of the scheme. Turning then to offence categories, and again, hardly surprising, we had a couple of categories of offence types come forward for maybe inclusion in the scheme. The first was hate crime and the second was crimes against the elderly, and we know the committee's interested in both of those. But we didn't have a lot of detail around that in terms of what the offence type should be. Most of the hate crime ones are already on the ULS list anyway, and we think we need to do some more policy work on those areas, so we wouldn't be proposing to add via the forthcoming order. In terms of delivery, as I said at the beginning, Chair, the Minister's proposing a two-staged approach. He thinks we should add now through an order so that we can give some immediate response to the results of the consultation consultation exercise, and then the other issues arising should be taken forward. Inevitably, if they need primary legislation, we're probably into the next mandate on those, and we don't want to wait to capture the benefits of the consultation exercise where we can. That's us, Chair. Very happy to take some questions.
Okay, thank you very much. Just first of all, you mentioned about the 28-day time limit, and I understand about trying to speed up justice and all that kind of stuff, but one of the issues that victims have raised with this committee in previous inquiries was that actually a longer period of time may be of benefit, and the police had suggested a 56-day period. I just wondered what the rationale is for sticking with 28 days and whether that's something which the department will keep under review.
We'd be very happy to keep it under review, particularly when we're looking at the broader policy issues. Arguably, you can look at it from the other angle that if you don't have surety on the sentence in a fairly tight window, then the victim, their families, the community, the defendant even really doesn't have a final a closure to the case. So 28 days is where we are at present, but we're very happy to keep that under review.
And what would the circumstances be that would lead you to look to extend that time limit? I mean, if victims are saying it, the police are saying it, I just wondered, it's kept under review, but what would need to happen in order for you to look to change it?
I think we'd have to be sure that going beyond 28 days wouldn't extend too far that window of clarity for people. I suppose there's some assurance of the system as well with the 28 days that beyond that the matter is concluded, but we're open-minded on it, Chair.
And in terms of the animal welfare, it's an issue that over the last 12 months seems to have got an awful lot of attention. There's a lot of public concern, and we've seen some fairly horrific examples of animal cruelty in the media. I appreciate that you're waiting for the end of the DARD, the work that DARD are doing. So if that's finished at the end of the year, would the intention from the Minister be to bring an order before the end of this mandate, if the mandate runs its full term?
Yes, it would. Yes, if we can get clarity on those offences. And I suppose I'm not predicting any extension of that review period, but I think if we thought we couldn't get some of these onto the statute book before the end of the mandate, we could move forward with one order and come back to animal welfare if we had to. But we're so close to the end of the review now, we think there's merit in just seeing that through.
And on the issue of attacks on the elderly, again, one of those issues that there's huge levels of public concern, and politicians are concerned about it too. We had a debate around the last Justice Bill about whether or not minimum sentence. People perfectly legitimately don't like minimum sentences, they understand that, but there is an issue there. So I just wondered what the thinking is around how we can give reassurance to the community that it's being taken seriously, and what sort of work's going on around attacks on the elderly or crimes that are targeted towards the elderly.
Well, I think certainly in the context of this exercise, it would be difficult to just have this concept of attacks against the elderly embodied in a specific and fairly limited order. I think the Minister said that is a matter of concern to him, and as Karen's suggesting, that there are probably broader plans in hand around sentencing and getting sentencing right, I suppose, in the first instance, rather than trying to fix it up, I suppose, by way of a little order. So there's further work, as Karen suggests, to bring that forward.
And just finally, I noted in 3.28 you talked about a planned broader sentencing policy consultation. I just wonder what the timescale is for that, when that work will be done.
At very early stages of us thinking that that's something we should be doing. I think if we get something out in this mandate, that we might just achieve that. But inevitably, anything that's requiring primary legislation now need to be rushed, because we can't deliver it until the next mandate, really.
Okay. Alban?
Thank you very much, Chair, and thank you very much for your detailed outline to the committee. What is the legislative vehicle that you use to put additional offences onto the statute book? How is that done?
It's a statutory rule by negative resolution.
Right, and so that's a fairly easy method.
Certainly compared to primary legislation.
Yeah. So if there was some conclusion in relation, for example, to animal welfare offences, that could be done fairly quickly.
Certainly, I think the process of bringing the statutory rule to the committee and so on could
Yes.
be readily delivered, yes.
Yes. Now, just one further question. The position now is that it is the Director of Public Prosecutions. He will, if a case is referred to him, he will examine the case and say, whether or not he feels in his opinion that it's unduly lenient, and then he would refer the matter to the Court of Appeal. That's the system.
That's correct.
I have some reservations about that, because it seems to me, in a sense, the Director of Public Prosecutions is almost like a judge in his own cause, because to some extent the prosecution have made an input into the sentencing at court level, and it seems to me that if there has been an understanding in relation to sentencing, that it may well be that the Director might not refer that matter to the Court of Appeal. Would it not be better to have an independent person doing that, assessing these cases, and would it not be appropriate in circumstances for the Attorney General to be the person that determines whether or not a case is referred to the Court of Appeal? I think that was the previous system. Some years ago, I think that was the system.
Didn't hear anything of that sort in the consultation exercise, and it is the scheme we have at the moment, and the proposals we're making wouldn't touch on that issue.
Yes.
Tom, is there anything you can add about the
Just on
system?
the independence point.
Yes.
I know that the director, when he's considering referral, does involve a senior independent barrister who's not been involved in the case before he considers referral. So independence built into his process.
And if that particular system were to change, it would be a matter of primary legislation, would it?
It would. And I don't think we currently have any plans to make a change of that sort.
Thank you very much, Chair.
Okay, thanks, Alban. John?
Thank you, Chair. Sharon, what will be the test for a case to be referred back, to prevent all cases come back, or people feeling that they had got an undue sentence?
At the risk of quoting some law, I mean, the statute refers to undue leniency, and it had been tested in the courts. So a sentence unduly lenient where it falls outside the range of sentences which the judge, applying his mind to all of the factors, could reasonably consider appropriate, and in that connection regard must of course be had to reported cases, and in particular to the guidance given by the court from time to time in so-called guideline cases. So they would apply that.
And where would it sit within sentencing guidelines? There are particular offences, there are guidelines.
In terms of sentencing guidelines in Northern Ireland law, sort of cases would be in guideline judgments from the Court of Appeal, to be honest. That's where they would look.
Paul?
Yes, thank you. With regards to the decision not to expand the scope of the scheme to all cases within the Crown Court and then also the Magistrates Court, with the additional offences being registered, are there any of those, and excuse my ignorance for this because I just don't know, are there any of those offences that would be placed in the Magistrates Court? And also, where's the differential in the Crown Court? Where does the separation come, where ones that you can put to the Court of Appeal and ones you can't?
Well, none of them would really be from the Magistrates Court. What we're adding into is a list of hybrid offences that could be dealt with in either, but are dealt with in the Crown Court. So it's typically the serious cases.
So they would all be Crown Court?
Effectively, there would still be Crown Court cases excluded, but
Yes.
this list would all be still coming from the Crown Court. Whenever the Court of Appeal is looking at an unduly lenient sentence case, it in itself is bound by the originating court's powers. So, to take magistrates' courts, for example, if you were to include all magistrates' courts cases where the maximum custodial penalty in the magistrate 6 months, there's the referring sentences might got 3 months to go to the Court of Appeal. That might go up to 4 or 5. There's a potential to undermine the confidence and so on. But to answer your question, effectively they're all Crown
Court cases. The chair's already alluded to it with regards to what people out there really, what really ticks their boxes with anger and frustration in these cases, these types of cases. It does centre around the welfare of animals issues and offences, hate crime, and then attacks on the elderly. And I see, reading the report, you've taken cognizance of all of those, but you're grasping, you're struggling with how you actually get that into the attacks on the elderly in particular. You're struggling to get that down as, how do we actually get that onto a piece of paper? What's the key? What do you need to happen before that would ease that frustration and concern for you? Because you know, age would be a massive factor. You know, what constitutes elderly with regards to an elderly crime, you know, a crime against an elderly person. Is it things like that complicate the issue for decision makers and policy makers?
But I think it was the broad nature of the recommendations that came to us through the consultation that, as a category, crimes against the elderly. But we have to be, I think, very, very careful before we add to the list of sentences. We do struggle in the department with the concept of having a list, I have to say, because why should one offence be on and not another? But when you look at the scale of what we could bring forward and the impact that that could have on the court system,
yes,
and on confidence issues, we just need to be very careful. So what does that mean? We just need to take that away and do some more thinking, but we really didn't want to lose the opportunity to move forward with the specifics.
But is workload on a court really, should it really be a determining factor? And does that not cloud justice then in that degree?
Well, I think we've got to be realistic. If we added an extra, say, 800 offences to the list without understanding how that might play out, I think we just got to work through the analysis of that and see where that takes us. And specifically on the issue of crimes against the elderly, which crime types are we talking about? How would you define it? Which ones are people really wanting to see added to the list? Is it everything? Is it the fact that the victim is elderly, or is it a specific crime against an elderly person? We just need to do that analysis.
I think you're right when you say, ask what are the limitations. I actually think the nature of the instrument that we're working with isn't, rightly or wrongly, is in itself a limiting factor. As Karen says, we can't just add on to it crimes against the elderly. The nature of the instrument that we're trying to update requires offences, and what we were getting was a broad comment that, as Karen says, probably dealt with in a better way.
With regards to some of the issues that have, or the offences that have been placed, like inflicting personal injury with a weapon or without a weapon, you can understand how, depending on the age of the victim, that takes on a different course, even, or a different mindset with the population. So, and again, they're all serious offences, of course, but you know, if you were to inflict personal injury onto a 25-year-old, or if you were to inflict personal injury onto a 75-year-old, you can see straight away the difference that would have out there in the population. So even with the categories that have been added, is there something of a subdivision that you could add even then to take into effect the age of the victim?
I think what we rely on in this area is sentencing practice and what are aggravating and mitigating factors in sentencing. And I mean, if you look at the court judgments and the guidelines, age, vulnerability of a victim and so on is an aggravating factor in the sentencing process anyway.
Anyway, yeah. Well, is the DPP the only body, person, group, organisation that can actually put these forward to the Court of Appeal?
Correct.
He or his deputy can do it. And again, in his sort of own guidance notes, he can take recommendations from victims, their elected representatives, or his own prosecutors. So he can be approached by a number of people, but you're right, in law he is the person, or his deputy, who refers cases.
With regards to the last range of questions, Chair, with regards to the welfare of animal stuff, which is a massive issue out there with the population, with regards to attacks on animals and pets and everything else, and the horrendous nature of that, it really does anger and frustrate the people in the population out there, our constituents. I can see where it would be wise to wait to see what the Review of Welfare of Animals Act brings out to that, but then will that be a case of you then, if you like, copying and pasting offences over? or will you be adding and strengthening to those with regards to?
Well, I think there's two elements there. Does the review suggest that the law needs to be changed more generally? Do sentences need to be strengthened within the legal framework? and secondly, which offences could be added to the list of unduly lenient, and all of that's in the mix in the DARD and DOJ review at present.
Okay, thanks very much.
Okay, thanks, Paul. And I suppose the point about approaching the DPP in the 28 days thing, it's some evidence that the committee has taken is that the victims perhaps aren't in a position to do that within 28 days, and that was one of the concerns that was raised. But Raymond?
Thank you very much, Chair. And my apologies, but Tom, when you were answering Alvin's question about the legislative route, it's secondary legislation, is that always in the gift of the Minister? So, like, if a committee or a member wanted to add something to the list, we have no route to do it, we'd have to use the primary route?
That's correct.
Okay, thanks. That's clear enough. I just have a couple of broad questions. In terms of the categories, would there be a provision to say if a conviction is around domestic violence, then there should be a route for the DPP to ask for a sentence to be reviewed, or has it to be a specific offence?
Specific offence.
Okay, and I mean, this is a sort of particular case which I worked on. Is, a prosecutor sometimes tells you that they have a degree of evidence, and if they go for the higher charge, then the threshold's higher. Therefore, sometimes they don't get the conviction, so they go for a lesser offence, but with a better, and in this instance, they get the conviction. But when the judge is dealing with it, the difference between, say, grievous bodily harm and actual bodily harm. Grievous bodily harm you can appeal. Actual bodily harm you can't appeal. So if a person pleads guilty and it's a domestic violence case, then the judge sometimes doesn't get the full view of it, and then the person ends up getting what everybody considers, and I think in fairness, in this instance, even the prosecution were saying they thought it was unduly lenient, but they had no route to challenge it. I'm just wondering if any thought would be given around that sort of category. And the reason why I say it, sometimes it's the same with, say, where a person loses their life as a result of, let's say, a car crime. Again, there are offences within car crime which can be appealed and some can't. So you can, obviously, I'm just wondering if there could be a category, if there's an offence committed where a person loses their life, then should it be subject to appeal?
And I think, we shouldn't lose sight of the fact that this list only talks about hybrid offences. Yeah. All indictable offences are within the scheme. They're not. So any of those domestic violence offences dealt with on indictment, this doesn't have to be listed. It's covered in law. But we can certainly look at, it's a similar issue, but you've got a broad category. What does it actually contain? What does it mean? We can certainly look at but typical offences. But
when the law is defining actual bodily harm, it doesn't say actual bodily harm in a domestic violence setting. It just say actual bodily harm. Therefore, it's not appealable. So it's how do you protect yourself? I mean, the point that you made to Paul about if it's in the magistrate's court, appealing it from 3 to 5 months, but actual bodily harm is not appealable, but it could be a very severe domestic violence. But because it's a single witness against the perpetrator, then the prosecution sometimes goes for the lower offence. They get a plead, but the person ends up being with an unduly lenient sentence.
I suppose the scheme is really to do with the sentencing rather than the prosecutorial decision, and there might be a danger that if we did that, it could become almost a second run at a case. Yeah. And the scheme's not there for that purpose at the moment. But we absolutely take your point, and we can look at that certainly.
Okay, thank you, Chair.
Okay, thanks, Sammy.
Thank you, Chair. Just a couple of points. I suppose the first question is that, forgive me if I come across a bit naive here, but in terms of the unduly lenient sentences, say in terms of animal welfare, is there a hierarchy of, let's just take, I think the Chair had mentioned pets. For someone could have a pet horse and someone could have a pet hamster. So if someone beat that horse to death and beat the hamster to death, to get the same sentence? Or can there be unduly lenient sentence? Say it was a cat, was there a category?
Category?
I'm not over the detail of the DARD legislation on that, but I do know, though, that the review is taking all those issues into account. That would be absolutely something that could be fed into the DARD review. There's something in that legislation, I think, that separates out domestic animals from other animals, for instance. But yes, and I suppose what's the purpose of bringing the prosecution to impose a sanction and to make sure possibly that the person is barred from keeping animals again? That would be the purpose of it, regardless of the poor creature.
Understand. Okay. My second question is in terms of the case filtering system. I know the Northern Ireland Human Rights Commission, they have cautioned in terms of allowing victims or representatives to initiate the reviews directly. What would your own view be on that, or the Minister's view?
I think the fact that it's in the hands of the DPP is the safeguard, and that has to be referred to the Court of Appeal. There is a danger that someone who just doesn't like the sentence or doesn't feel, and it can be that way for a number of victims, they just don't feel the sentence is strong enough. But you have to operate the principles we have at the moment about an error of judgment and unduly lenient. We can't keep just running cases over and over again. So yes, I absolutely take that point. However, the ability of victims to feed their views into the DPP is absolutely vital.
Absolutely.
Somebody should have the right to say, I don't think that's correct in my case, but the decision should rest with the DPP in our view.
Thanks, Aaron. Thank you, Chair.
Okay, thanks. Aaron?
Yeah, thanks, Chairman. Apologies for being late. I'm not sure whether Frederick's story at the family's hamster or what his concern is about hamsters, but nonetheless, in terms of this proposal here, I brought forward an amendment to the previous Justice Bill relating to offences against the elderly, and with retrospect, I should have expanded that to vulnerable people in general, as opposed to just elderly. But I have to say, I'm very uncomfortable that, you know, if someone carries an assault out on another individual, and in the process of that they call them an orange bee or whatever, that becomes a hate crime. Or indeed, if they carry it out and they have a go at someone about their sexuality, that becomes a crime of greater significance. But if someone attacks an elderly person, or indeed a vulnerable person, someone who's learning disabled, someone who's physically incapacitated, then we don't have that kind of strengthening of the law. Now, I know that a judge or a magistrate, whichever the case may be, should take all of that into consideration, but we have enhanced the law in regards to these other circumstances, and yet with all of the right people that exist within the Department of Justice, we can't find a means of actually providing that enhanced support for the most vulnerable people in our society. And that's, I really think that we need to do more work on supporting the vulnerable people in our community.
We touched on it before you came in, Mr Poots. I think we're proposing some specific offences to be added today, but we're taking away that particular issue for further consideration.
Yeah, well, that's fair enough. I really appreciate it, because I don't think we can just let this one go. And I indicated to the House, I wasn't dissatisfied at actually losing the amendment because of the timing and so forth of it. But it's not something that I want to drop. It's something I think this House can do more on, and the Assembly can do some credit to itself, but more importantly, actually provide greater protection for people who are in most vulnerable circumstances. I have came across circumstances where people who have learning difficulties have been attacked. In fact, there was one of my own constituency lately, and it was a very high profile one, and the case has now been through the courts and so forth. And I just think that, you know, we really do need to provide a greater level of care and support for people who have learning disability, people who have disability in general, and the vulnerable, which is generally, you know, younger children and older people. The rest of us shouldn't be attacked, but it will probably take less out of, you know, someone in the in-between category to if they are assaulted than it will for a person who's maybe in their late 70s and very, very frail.
I just comment on one aspect of that. I fully take your point about the elderly. It's probably a little known fact, but hate crime law does actually already cover disability. When we created that a number of years ago, it went through a lot of categories and disability was added into it. So in terms of attacks against the disabled, the law exists, but I take your point.
And how's that applied then?
Well,
You know, if is it just applied to everyone who happens to be elderly vulnerable, or is it only whenever someone calls them, you know, an old curmudgeon as they're assaulting them?
Well,
They have to demonstrate.
it's about demonstrating motivation of hatred on those
Yeah.
grounds. I mean, there are issues around how you demonstrate motivation, I have to say. But just on a point that it's actually listed.
Yes, so technically it can be done.
Yes.
Has it ever actually happened?
I couldn't, honestly.
Yeah. That's I would want something a bit more encompassing than that then. Okay, thank you, Chairman.
Yeah, I think the whole issue of hate crime and what defines hate crime and how you prove what's in somebody's head is incredibly difficult and probably a debate for another day, but it's certainly an interesting one. Nobody else has indicated, so thank you very much. Tom, I understand you're leaving us under the voluntary exit scheme.
Yes.
The rest of us might be leaving under the involuntary exit scheme, but nevertheless, I just thought it was important to note your work. I know you were particularly involved in the First Justice Bill.
Yeah.
Just thank you very much for all your time.
Thank you.
And enjoy your retirement. So
Yeah,
thank you very much.
Okay.
Thank you very much.
Thank you.
Okay, members, if we then move on to... Okay, just before we move on then, are we content then with the approach from the department? Any other comments to make? I think we've certainly noted the comments that Edwin made. I think generally there's an agreement around some of those issues that are important to the public, so we generally content then.
I suppose one thing we should add probably is the realisation of time constraints here, and even though the welfare animal stuff, the review of that is coming up soon, I would have concerns about trying to get it, getting it through in time for this mandate, and then who knows after that. So we need to be careful that we don't lose the opportunity to actually reform this.
Yeah.
And Chair, could I just come in there? Paul's point, there's at least one other member of the Assembly who wants to bring other amendments in that. So have we made a decision, is it one, we're going to allow another one or another three or whatever? All I'm saying is obviously time's a big constraint for the work that we're doing at the moment. Yeah. Need to make some sort of decision because some of that stuff will be coming our way.
You're talking about the Justice 2 bill?
Yeah.
Yeah, it's a slightly different issue, but
But it's all work, that's what I'm saying. It's more.
yeah, it may well be more work. I suggest there'll be more than two people bringing forward amendments to that bill, particularly if we're heading towards an election. But yeah, it's a point that's been noted. I think everybody understands it. Okay. Not that everybody listened to it, but I think they understand it. Okay then, move on to agenda item 5 is the Northern Ireland Police Fund regulations. If I refer you to pages 92 through to 101. Just to remind the committee, in April of last year, the committee considered and agreed it was content with the department's proposal to make a statutory rule under the powers conferred by the Financial Provisions Act 2014 to provide for the constitution, functions, procedures and financing of the Northern Ireland Police Fund. There's been a delay in the department laying the statutory rule while the Charity Commission considered the charitable status of the Police Fund. The Commission has recently confirmed that the Police Fund does not meet the legal requirements to be registered as a charity in Northern Ireland. This clarification was required before the Department could proceed with laying its proposed statutory rule. As a result of the delay, the Department has resubmitted the proposal for the statutory rule for the Committee's consideration and has advised that the policy intent remains unchanged from the previous SL1. The rule will be subject to the negative resolution procedure and will come into operation at the earliest possible date once made. So just ask the Committee, are we content then with the proposed statutory rule?
Yep.
Okay. Agenda item 6 then is Committee Work Programme, referred to pages 103 for the relevant papers. The Committee held an informal strategic planning meeting on the 3rd of September where we identified the key priorities. The paper setting out the priorities as identified by the Committee and the work to be undertaken until the end of the mandate is at pages 104. As part of the Committee's work to identify and discuss innovative approaches that could be adopted to improve the efficiency and effectiveness of the justice system in Northern Ireland, members will remember that we took a 2-day visit to London in June. Myself and the Deputy Chair visited Holland during recess to meet with members of the Justice Innovation Institute. There's notes of both those visits included in the pack from pages 109. If anybody wasn't there, I think probably Neil would be interested in reading through those. I think it lends out a useful reminder of the issues that we discuss with each of those organisations. And particularly given that most of you weren't in Holland, I think it gives a pretty good note of our meetings with Europol and some of the issues there, with Hill, who are coming over obviously for the seminar next week, and the Dutch Council of Judiciary, which is another interesting way in which they structure things. So it's worthwhile just having a read through those for members who are interested. Agenda item 7 is proposals to extend the powers of the Criminal Cases Review Commission. Can I refer to page 144 of your packs? The Commission wrote to the Committee outlining the need for an extension to its power to obtain documents from private organisations and individuals, where it is reasonable to do so and under judicial oversight. Following a meeting the Commissioners held with the previous Chairman and Deputy Chairman back on the 30th of October 2014 to discuss the work of the Commission, the Committee subsequently considered a proposed public consultation on the issue by the Department and agreed that it was content for the consultation to take place and to consider the matter further when results were available. The Department has now provided a summary of the 10 responses it received to that consultation, and these responses are largely supportive of the suggested change and the proposed safeguards, with the importance of protections for private organisations and individuals, including consideration of human rights and data protection, being highlighted by the Attorney General for Northern Ireland and the Information Commissioner. In view of the general support for the proposal, the Department does intend to legislate for this change. The Ministry of Justice is taking forward the same change in England and Wales, and the opportunity exists to include provision for Northern Ireland in the Criminal Cases Review Commission Information Bill introduced in the House of Commons by a private member in June 2015. The Department has indicated that it would be unable to make the change by way of an Assembly bill until the next mandate. Therefore, the Minister is seeking the Committee's formal agreement to lay a legislative consent motion in relation to this provision to enable it to be in place within the same timescale as England and Wales. So, members, if we note the results of the consultation, can I ask if members are content with the proposal to extend the powers of the Criminal Case Review Commission to obtain documents from private organisations and individuals, or has anyone any other questions to ask? Generally content?
Right.
Okay. And we're content for the change we made then from by way of legislative consent motion? Yeah?
Yep.
Okay. Agenda item 8, future regulation of the private security industry, pages 177 through to 194. The Department has provided a written update in relation to the position regarding future regulation of the private security industry in Northern Ireland and the cost implications. Following the Public Bodies Review in 2010, the Westminster Government announced there would be a transition to a new regulatory scheme in England and Wales. Following a consultation in 2013, the Minister of Justice decided that Northern Ireland should continue to be part of a UK-wide regime with a move away from individual licensing to business regulation. The Home Office had initially intended that regulations to introduce business licensing would be made by the end of 2013, but the timescales were significantly delayed as the Home Office was asked to consider how the potential cost of business licensing and the potential regulatory burden placed on businesses could be minimised. The Department of Justice indicated that it continues to press the Home Office to reach conclusions, but has been advised that whilst the Home Secretary still plans to introduce regulation in this Parliament, it will not progress until after the outcome of the planned triennial review of the Security Industry Authority, which is due to be completed by March 2016. In the meantime, the current regime is continuing to operate in the interim period. So again, members, that's just for noting the current position. Agenda item 9 is a progress report and implementation of the Victim and Witness Strategy 2015 to 18. If I refer you to pages 196 of your packs, the Department has provided an update and progress to deliver the 2015 to 18 Victim and Witness Strategy Action Plan. The update indicates good progress has been made in the 15 actions due to commence in year 1 of the plan, including the introduction of mandatory training relating to victims and witnesses for PPS staff and panel counsel, the completion of phase 1 development work on a new victim information portal, and progress towards the introduction of a pilot in Laganside Magistrates Court to improve waiting time for witnesses. Work over the next 6 months will focus on a range of issues, including work to develop a new witness charter and a consultation on a revised Public Prosecution Service victim and witness policy. So again, members, that's just for noting, unless anyone has any questions on it. If not, agenda item 10 is correspondence. Just to highlight a few items for you. Item 1 at page 213. correspondence from the department providing a copy of the cross-departmental implementation plan, producing response to the recommendations contained in the Marshall report of the inquiry into child sexual exploitation in Northern Ireland. The department has revised the DOJ action plan to provide greater detail and reflect the key milestones in the cross-departmental implementation plan, as provided a copy of it. So again, that's to note both plans, unless anyone has any other issues, and perhaps it would be useful if we agreed that we request 6 monthly updates on progress to deliver the Justice Plan as well. Yep. Item 4, page 244, is correspondence from the department providing an update, as has been requested by the committee, on Access NI performance and the position regarding the processing of enhanced checks. The department has indicated that Access NI is currently meeting all of its public performance targets. In relation to enhanced checks, currently with PSNI, there's been an improvement both in the total number of outstanding checks and those that have been delayed for the longest period of over 60 days. The minimum time for a check to be returned by the Police Service in Northern Ireland has also reduced from 19 days to 12 days over the same period. The department has also highlighted that during September and October they will face a significant increase in the number of applications received, and this will have an impact on the throughput of cases, I suppose, given that schools are back and youth clubs are starting up again, things like that. So members, that's just really again for noting, unless any further information is required. We will get a further update in October, which I think will be useful just to keep us on top of it. Item 11. Page 266 is correspondence from a number of individuals requesting an update on the position regarding the PSNI civilian staff equal pay claim. At the meeting last week, the committee noted a response from the Minister outlining the current position regarding this issue. So, if members agreed, we'll forward a copy of the response from the Minister to the individuals who have written to us, and for the response to be provided to any other individuals that may write to us on that same issue in the future, if we're agreed. Item 1 in the tabled pack is at page 5, is a copy of correspondence from Dolores Kelly to the Department of Finance and Personnel regarding the implementation of the 15-16 pay award for staff in the prison service, which was forwarded to us by Patsy. Members will recall last week we raised this issue and that we agreed that we would request an update in this matter from the Northern Ireland Prison Service, and further consideration can be given to it when that response is received. So we'll wait until we get that back into the committee office. Any other items that members wish to raise from correspondence?
Chair, just in relation to the update on proposals for civil legal aid, remuneration and civil and family courts.
Yep.
That's a response by the Bar. I think it's significant to note there that what they're saying is that whenever changes were made in terms of representation by way of counsel, barristers in the family proceedings court, that the level of certification now is 0.3% against a projected rate of 10%. And what they're suggesting is that this is leading to underrepresentation for families in cases such as domestic violence, non-accidental injury to children and sexual abuse. And I think that's a serious development, and I think it's one that we should note. I'm not saying we do anything at this point in time. I know there are ongoing discussions between the Bar and Department of Justice, but we should really be aware of the adverse impact of some of these changes in relation to ordinary people who need help, professional help, and yes, the department's saving money, I'm sure, but it does have another price in terms of the social adverse impact that there might be. So I'm just raising that and highlighting it.
We had a briefing on it before the summer, and I think we'd asked the department going to look at it, so maybe chase that up with them and see if they've anything further information for us. I think it'll be useful enough to do. Agenda item 11 then, Chairman Business. Nothing really, just to say yesterday I spent a day down at the courts. Wasn't the dock or anything. I had the opportunity to meet with a number of judges and have a conversation with them and sit during different cases and different tiers of the court. A very useful experience, and this was in the back of what Alban said, looking at the listings for the week and the number of personal litigants as well, and the impact that that's having in justice being delivered for those people is quite significant. But a number of the judges said that they would be happy to facilitate any member who wanted to go along and do something similar. It's something as individuals maybe it would be easier to do, even spend a half day there, just in terms of understanding I suppose the workload on some of the courts, particularly at the magistrates court level, and also just getting a tour around the Bagonside courts and seeing the plans that they have for the family courts. It was very useful, I found, and again I think it was good that they offered that to any other member who'd be interested. So if you were interested, maybe contact Christine. Agenda item 12 is any other business? Is any members any other business to note? I noted the successful use of the tablet device from Alban today. All hope is not lost. There's a Luddite on this side of the table today, but
Sammy's in
I get some honour or pride. I thought a mention was enough. I don't know how able you were here in the business there, so it's very good. So agenda item 13, date, time, place, the next meeting. Just to remind members that we have our Justice seminar again next week. The guys from Hill are over looking at the online dispute resolution stuff. This stuff is really, really interesting, and I know some people are a little bit nervous around the impact of it. I still think this is going to happen, and it's a way in which, particularly when we have more people representing themselves in court because they don't have enough money from legal aid and everything else, this is a possible way of looking at particularly compensation claims. And of course in Holland they're using it for divorce proceedings as well. It's a really, really interesting one, so if members are able to come along to that, it will be very, very worthwhile, and we'll try to arrange a lunch before that as well. So then, as a consequence of the meeting, the formal Justice Committee will meet at 3 o'clock, and we'll have our seminar at 1:30, so we'll get a reminder sent out to everybody. Okay.
Committee Room 30. This is the Northern Ireland Assembly Committee Room 30.